SJC-12656, Justina M. Szafarowicz v. Commerce Insurance Company.
Welcome back, Mr. Graceffa. Give us a moment. Okay.
May it please the court, John Graceffa here for Commerce Insurance Company. With the permission of the court, I would, since it's the same case, I would just like to point to something in the record appendix, which was, I think, a lingering question from the first appeal. And it's actually the record appendix in this case, the Szafarowicz wrongful death case, and it is volume 3, pages 44 and 45. That is a letter which was sent to Mr. Gillis by Mr. Slotnick on behalf of Commerce, offering the $20,000 compulsory limit with all the accrued interest on the $7 million judgment as of that day, which was $73,347.29. And just one other point.
Can I ask, do you agree with their view that you would have ended your liability for interest by offering $20,000 and 1 day's of interest on the first day?
Well, if that's their position, I think that's exactly what we did, Your Honor, on the 17th.
I'd like to know, I mean, if that's the case, this is a pretty expensive proposition. I just want to understand sort of the bigger consequences in these cases where you've got compulsory and...
This is sort of like the first game of the doubleheader going into extra innings, so.
But I would like the answer to that question. Do you agree that if you'd offered $20,000 and the first day's interest, you would have stopped the interest from accruing under the, is that right?
Well, if that's their position, and we did do that.
But you did it later. I'm trying to understand how big a problem all of this is. But do you agree that $20,000 plus 1 day would end this? Is that a correct interpretation of that insurance policy provision?
Frankly, Your Honor, I haven't thought through that question, and I'd like to before I answer it.
Okay,
I think the answer to it is, as we understood it, our obligation after the judgment was to offer the uncontested $20,000 plus the mathematical amount of $53,000 and change, which we did. And at that point, that happened in February of 17. Now, moving to the, I'm sorry, Your Honor.
No, I'm happy. Go ahead.
Moving to the second piece of this. Part of the argument in Appeal 1 crosses over to this, because I've already spoken about the consent judgment. We researched mass law in regard to consent judgment. It seems to be the estate's position that the agreements that they executed in December of 16 were accepted practice in the Commonwealth. I want to distinguish two cases away. The Gore case, which I know this case is familiar with, and Arbella versus Gore, was a bad faith case, number one, and Arbella consented to the settlement, number two. Doesn't apply. This is also a situation where this is not a defense defaulting insurer. From the beginning until today, Commerce has offered and is paying for the defense of both the Padovanos. There is no breach in any way of the insurance contract, which is a huge point, because at the point they entered into the settlement agreements, as the amicus briefs point out, they breached the voluntary payments clause at that point. We do adopt the arguments.
If I can ask you about that.
Yes, Judge.
I've not had much time to do any research. I don't find any cases in which there was a reservation of rights. Do you get the entitlement to say, well, we're not promising we're going to pay any
settlement, but you can't settle without us.
The closest case is the one cited by the amicus, the Orchard case.
Yeah, it's not that close, though, because that was done early. I'm not sure there was even a reservation of rights. There, they settled it even before they had notified the insurer. So, I mean, the argument would be, I mean, I've looked at the amicus, and I know that they argue it more vigorously than you do.
Right.
But when you do a reservation of rights, are you still entitled to say, although we are not going to pay the settlement if we win the DJ action, you still can't settle it without us?
It's a closer question, Your Honor. And we didn't argue it for two reasons. One, we contested the validity of the entire agreement. And number two, a couple days after the agreements were executed, we moved to file a supplemental pleading, an amended complaint for breach of contract. We wrote letters to the two insured saying, if you do this, you're in breach of the cooperation clause. Those were ignored. They signed the agreements. We moved to amend the complaint, and that was denied. So the amicus argued that. I think they're good arguments, but we believe that it's only another factor in the invalidity of the consent agreement in toto.
Okay, now let me see if I can understand how you are now prejudiced by it. I gather that Judge Wren, because he found in your favor, did not give any credence to their stipulation of negligence.
Correct.
So you were not prejudiced there as to that. They stipulated as to negligence, but it didn't matter, because Judge Wren apparently didn't consider it at all in his decision.
Well, he could have gone the other way, Your Honor, in that situation. I mean,
Okay, but I mean, but how did he treat the stipulation of negligence?
it was not part of the declaratory judgment case.
Okay, so you were not prejudiced in the sense that that in any way changed the terrain for you in the DJ action?
That's correct. I agree with
Okay,
that.
so, and you're not prejudiced in that, assuming you prevail on appeal, you have no obligation to pay any part of the settlement amount, except arguably for the post-judgment interest.
Well, there was no settlement, there was a judgment. But
Judgment,
ye-
okay, I'm sure you're right. There was a settlement, which,
Yes.
there was a
Yes.
settlement as to liability and said,
Correct. Correct.
we agree that the issue of damages shall be determined by the court.
Correct.
And you will not, whatever the 8 million is, you will not have to pay that. The only issue, it seems, that you're prejudiced by it is that they have now done two things. They've markedly increased the amount of post-judgment interest that you arguably need to pay,
Yes.
and they arguably, if they were to prevail in the DJ action, ultimately, then of course you'd have to pay it. And they arguably, if there's a 176D action, they'd be doubling or trebling
Yes.
that amount.
Yes.
Are those the three areas where you're prejudiced ultimately?
Yes. Yes.
So that's what it comes down to.
Well, the term judgment, as this court well knows, has significance on 93A and 176D, as well as the significant post-judgment interest.
But you wouldn't be if the $20,000 rule applied. If that's correct, and you offered the $20,000 and one immediate, $1 a day of interest, then you wouldn't have been prejudiced, right, by this? Because post-judgment interest would not have been able to accrue. You would have turned over, there's no dispute that you owe the $20,000.
Well, if they're arguing, as I think I heard this morning, and I think we did, we offered what we owed back in February of 17,
Yeah, but
then
this
the whole
case-
post-judgment interest point is moot. We don't owe it. I don't think that's their position, but that's what I heard.
Well, no, that's why I'm flabbergasted too, but it changes the entire dynamic of everything we've heard, if this is the case, because there's a way of avoiding the post-judgment, at least in these type of split insurance policies.
Well, the way I have always thought about this, Your Honor, is we have two limits in this policy. As in every policy, we have a 20/40 compulsory limit. That's always been out there. That, we never contested that. we had the other $480,000 out there, which was a whole fight in the declaratory judgment action, and why we tried it last summer, and we prevailed. We attempted to pay what we owed on the $20,000 plus all the interest back in February of 17. But in our view at that time, the $480,000 was still in play because of the declaratory judgment action and whether there had been an accident and customary use. I mean, that was the case we tried this summer. I mean, if they're conceding that we don't owe any post-judgment interest, I mean, why do we go through that exercise? I'm sort of mystified by that.
They're saying you kind of blew it. You would have owned no money if you'd put it up right up front, but now you do because you didn't.
I don't see that, Your Honor.
No, I understand. It certainly changes everything in the briefs because everything we studied, the big problem was the accrual of all the interest.
Right.
But if there was a way around that, the case becomes less significant.
Well, to go to this part of the,
Because like what the first judge did, I can't remember, it was Judge Davis, the prejudice point, allowing you to contest liability if it wasn't fairly litigated. That seems to handle most of the problems, and it did because, as the Chief just pointed out, you weren't held to the negligence standard. You were allowed to litigate it over again. It's just the pressure caused by this giant post-judgment interest problem.
well, that's part of it, and Justice Gant's point on the fact that we had a judgment out there, we think unfairly assented to, that led to a $7 million award we need to contend with. Under the cases around the country, starting with that Miller-Shugart case, which we looked at, this particular agreement with a company that's been defending since the inception, and there's been no credible argument that Commerce in any way breached its obligation under this policy, it's our contention under Part 1 of our brief that they did not have the right to do this. There was no breach. Justice Gant's point's a good one on the reservation of rights situation. We were reserving our rights, but there's a bona fide coverage dispute going on at the same time. The second alternative outlined in the second part of our brief is that, okay, if you're going to enter into this type of consent agreement, there has to be some safeguards. This particular agreement, as we see it, and as outlined in the brief, violated every single standard generally accepted around the country. No limitation of the policy limits. There is no trial in any mini-trial sense or anything on negligence. They threw away comparative negligence. And I would ask you to read Judge Wren's decision in regard to the actions of Mr. Szafarowicz versus Mr. Padovano in terms of comparative negligence. Judge Wren found that Mr. Szafarowicz was the aggressor.
But isn't that the point? I mean, going back to what Justice Kaffer just said, if they're under litigating this case, and it is unfair to you, Judge Davis indicated that you could relitigate in the declaratory judgment action, right?
Not the fact of a judgment. We went into that. We went into the case that we did this.
Damages. Just damages?
Yes, yes.
Okay.
And the point made in their brief that Judge Davis gave us the ability to relitigate damages is irrelevant. Damages has nothing to do with our coverage obligation. We litigated fairly in the declaratory judgment case, the customary operator and the accident point. Fine. Going back to December, the estate and the Padovanos, without the participation or permission of Commerce, entered into those two agreements. At that point, once those agreements were signed, under litigation became non-litigation.
Yeah, but it doesn't matter except for, none of it matters except for the interest, because if you lose, there's no question the $500,000 is going to be in play, right?
Right.
I mean, the guy has 5 children and he's dead. So the only way you're capped at $500,000 if you can cap the interest right up front. It's, the interest creates all the problems, but now we're being told the interest goes away. So how are you prejudiced by Justice Davis's order if the interest problem disappears? Because he allowed you to relitigate anything that's not fairly litigated. I'm confused
He
now.
didn't allow us to relitigate the tort case, or whatever it was that they entered into, within the coverage case.
Yes, he did.
well-
What did he gave, he found negligence in $7 million. You just said the $7 million doesn't matter.
Well, to read it that way, Your Honor,
Well,
we
I'm
then
reading
would
it,
have,
I didn't until a half hour ago, but now I read it that way.
well, we would have then entered into the declaratory judgment case with a further burden on us to retry the tort case within that case and say, all right, we have comparative negligence, we have this, we retry damages. That doesn't make any sense. I think the fact of the artificial judgment without the participation of Commerce way back in December caused this problem. If they had come to Commerce,
Articulate something besides interest that you're actually harmed in, because I'm confused what that is. How are you harmed by that $7 million verdict except for interest? Just,
I have at least two 93A letters sitting in the file from the estate. And
saying,
under the statute and under the case law, as this court well knows, that term judgment has significance. And we think the judgment was artificially wrong.
How common are these agreements, especially when there's some criminal liability floating around? How common are these agreements, especially in the scenario with this criminal liability that floats around?
Uncommon in this situation. Before a judgment, to confess liability, to do an assignment. Uncommon, Judge.
So what, I mean, they're not, I mean, I've seen them, so they're not, you know, you can understand in this particular circumstance their point of view, which is to say, this is a terrible tragedy. We want to help the victim as much as we possibly can, and we want to help you maximize what you can, but as long as we don't have to pay it. So you're not quarreling with their ability to obtain a release through a settlement.
I'm quarreling with their ability to stipulate to liability and they didn't settle the case. They stipulated to liability, and they confessed to judgment comparative and so forth, and they only agreed to try damages without any participation from Commerce.
Okay, so what do you say the judge should have done when faced with that it's a partial settlement, it's a settlement as to liability, essentially?
Well, I think the case that is cited by the estate is supportive of their position, which, again, mystifies me. The Campione case and the Spellman case, both of those stand for the proposition that the burden is on the estate in that case to prove their case in full. And Justice Gantz, they
But
proved...
if they're settling the case, why would they have to prove the case in full? I mean, we allow parties to settle.
Well, they didn't settle it. They let it go to
Allow them
damages.
to stipulate as to liability, essentially, and
Well, to go to Justice Gaziano's point, the situation which this is not is a case that is tried to a jury, like the Bolden case, which resulted in a $20 million verdict, and then there was an agreement. It was an excess judgment. That's different. You have an adversarial proceeding in which both parties are represented, and there's a judgment. Here, all of that was wiped away. And under the cases that we cited in the brief, their agreement violated every standard. You have the Gandy, Texas case down on the one hand saying that if an insurer is defending, they can't do that. They just can't do it. That's the first part of our brief.
they can't
They can't,
settle the case, they have to try it?
they can't, if we're defending, they cannot confess to liability, as they did in that situation. We're not a,
You have a reservation of rights, even though you're not promising to pay any part of it, except for the 20 grand.
and we go back to the first point this morning, the reservation of rights, because there's a bona fide coverage dispute. That's an admittedly,
Last part of your sentence, it's what? Bona fide reservations, right?
because there's a bona fide coverage dispute, Your Honor.
Okay.
The second part of the brief is that if you do not accept that, if just because we're defending, they can't do such an agreement, okay, then let's have some safeguards. limit it to the policy limits, have asked Commerce for its consent, and so forth. Had they come to Commerce and said, we're going to craft an agreement, we're going to do it for $500,000, and then litigate the coverage case, I certainly would have gone to Commerce and recommended it.
But your point is, it's a matter of the contract, not, it's cut and dried, part of the insurance contract.
Right, right.
But I mean, I thought you were asking us to have essentially a fairness hearing with regard to the settlement, in which you participate, in which you can argue to the judge, no, you should not accept this settlement.
Yes, yes.
So,
Commerce was given no ability to participate in any way in this consent assignment. And it wasn't limited to the $500,000 policy limit. They simply were searching out a judgment, which they ultimately received.
okay, so where you're saying that Judge Davis erred or abused his discretion is that he should have said, this case needs the approval of a court, and there needs to be a fairness hearing with regard to the proposed settlement and disposition.
Well,
Is that what you're saying?
Judge Davis's decision was before the agreements.
Before the agreements, I'm sorry, I thought it was, okay, so it
So
would be,
we moved to intervene. Judge Davis wrote the decision and said that Commerce has a point, they need to be protected from under litigation. Then we moved to stay the case, to try our case first. That was denied. Then the agreements were signed, and then we moved to, so the sequence is
it's
important.
Judge Ricardoni who did the damage assessment hearing.
Yes,
You would say that Judge Ricardoni should have said, wait, I'm not going to do a damage assessment hearing, I'm going to do a fairness hearing as to whether this is an appropriate disposition.
well, the Superior Court at that point, if it went forward, should have put the burden on the plaintiffs to prove their case, all elements of their case, in some sense. That's what Campione
But what do
says.
you mean? I mean, I'm trying to think pragmatically. I mean, I'm trying to figure out which judge you said erred. So so he's supposed to say, I'm sorry, this case must be tried, as opposed to, you want to stipulate as to negligence, fine. But let me evaluate the fairness of this resolution. You want to say, no, we actually need to put aside 2 weeks to try it?
Well, that's an extreme position, Justice Gantz. To go back into the December piece of it, they didn't ask permission from Commerce. If we just said no, that would have been a point, but they never asked. Second, they didn't limit it to the policy limits. Reasonableness under the cases around the country includes the amount of damages, the fault, the comparative fault, and so forth. None of that was done here. The agreement just stopped that in its tracks, and all the Superior Court tried, they heard from the
Okay,
widows and the children.
I know what happened, but having been a former BLS judge myself, and the guidance we're going to give, if this were to happen again, is this is what you should do, Superior Court Judge. What is the guidance we give?
I think that this court, we laid out 4 standards in the brief that agreements of this type should be held to. Policy limit, they should be limited to policy limits. There should be a requirement in some form that they be reasonable in terms of numbers, be that the policy limit or something, and fault, and that the insurer have participation, and that's it. But we had none of that here, Your Honor.
Wouldn't it have been easier just to argue that he shouldn't have denied your intervention motion? Because, I mean, this is, to create these kinds of rules on settlements, sounds like we're gonna be, projecting all different kinds of situations. Was it an abuse of discretion to deny your motion to intervene?
Those are the other 2 grounds in the brief, Your Honor. And I think if the Superior Court had stopped the wrongful death case, and allowed us to try the case that we tried last summer on the declaratory judgment, we wouldn't be here. But it got reversed. And so I'm mindful, Justice Gantz, of the practical issues, but I'm also mindful of the fact that this was a train that we couldn't stop, and we ended up with a $7 million judgment. And I don't think that's fair to insurers or Commerce. But I see my time is up. Thank you for your attention and questions.
Mr. Gillis.
Thank you, Your Honor. Your Honor, I'm here to discuss two issues. One is the sequencing of trials. The second issue is the validity of the assignment of rights. But because of what I've heard already, I just want to touch on three things. First, Judge Lowry, in the Miller-Schuchar case, talking exactly what you said, it's unfair for both sides. They said, nevertheless, it seems to us if the risk is to be borne, it is better to have the insurer who makes the decision to contest coverage bear the risk. Of course, the insurer escapes the risk if it should be successful on the coverage issue. And in that event, the plaintiff who loses. So on the balancing act, all the courts have come up that it's the insurer because they drive the bus who should bear that risk. Judge Capro, on your issue, what happened here was, if, you're right, if from the day after, they pay post-judgment interest. After one day, there's $2,500 in post-judgment interest. If they pay it, they stop it. But as they told you, they didn't pay it until late February. And in the interim, there was a clerical error. The $150,000 for the settlement for the bar was not deducted. The clerk then deducted it from the judgment, but when she put it in for the new date as pre-judgment interest. So the first 30 days, which were post-judgment interest, became pre-judgment interest. We filed a motion to correct the clerical error. Commerce says, no, we're not, this is what it says, we're not going to pay that 30 days, and that's where that dispute is. But you're absolutely correct, and it's not disputed that all they owe is post-judgment interest up until the time they pay, and had they paid it the first day, it would have been done. In fact, they could have paid it between the time of the trial on the 19th.
What I was struggling with is what your brother argued in the first case, which is this 20 grand would have ended everything. So for $21,000 or something, this case, they would have eliminated their post-judgment interest requirement and then been able to litigate the declaratory judgment. It just seems like that's the big surprise to me, and it changes almost everything you've written in both sets of briefs.
That's because there's a condition here, Your Honor, and the question, and in this case, they would have only paid the 20. The condition is they don't have to pay any more post-judgment interest if they win the declaratory judgment action, which we know they did. Now, had they lost, then they would have had to pay it.
Right.
But that's their
that's
risk
fair,
they
right.
take by going forward and not just paying the policy limits, getting out of the case.
But I'm going back to the February 15th, 2017 letter, which I now have in front of me, and it offers to pay $20,000 together with accrued post-judgment interest of $53,347.29 for a total of $73,347.29. And it goes on to say, the acceptance of the payment will not be in accord and satisfaction of any claim, and Commerce will never look to get this money back. This money is paid unconditionally, and the estate may accept it freely. Does that not fit within the framework of an unconditional offer to pay?
No, Your Honor, because you'll see later in, I don't have the page, but you'll see later in the appendix, my letter back to them saying that as long as you're willing to say that this isn't going to affect any of our appeal rights or anything else on this, then we'll take it as unconditional. They did not get back to us. I sent a second letter after that saying that and sent the check back saying, since we have not heard back from you and you have not said that this will not affect any of your rights we have to go after any further interest, we're sending it back to you. After the clerical error was...
It would. I mean, they wrote it precisely to have an effect on the payment of further interest, but aren't they allowed to do that under our decision that Judge Graney wrote in Davis?
To pay some interest as opposed to all the interest?
Pay all the interest that is due at that time.
Correct, Your Honor, and that's why we didn't accept it. That's not all the interest. The 30 days that I just talked to you about, due to the clerical error, they refused to pay. They said that's all prejudgment. And when we filed the clerical, which was acted upon in April, they then, instead of paying it, filed a motion for reconsideration, which took until August. And then in August, by their own doing, they could have paid the $2,500 the first day. But now we're 9 months down the road, they owe all that interest, and they refused to pay it. They paid a portion of the post-judgment interest, and the rest they said, well, if we had paid it on that day, here's the loss of use of the money at a lesser rate. So they didn't. That's the dispute that might come up another time, and I don't want to concede my time on that issue because I have these other issues. Judge Gaziano, your point, it is very common. In fact, in the Polaroid versus Travelers case, it talks about these type of agreements should be encouraged. And they came up in Campione, it came up in the Spellman case, it came up in the Gore case, and it even came up in the Miller-Schuchar case that they cite from Minnesota that they base their appeal on. These are very common agreements that people put together. Getting back to the sequencing, as Commerce says on page 46 of its own brief, decisions regarding the order of proceedings are within the sound discretion of the trial court. This is not new or novel, and it was not abuse of discretion for Judge Davis not to have them participate in that first case. And there are several reasons for it, the first of which they haven't talked about, is the timeliness of these motions. We were 2.5 years into the litigation before the meeting at the court in October of 2015, at which time the court set the tort action down for trial in May, which is 6 months later. Commerce, up until that point, never moved to try the deck action first. In the 6 months that it knew that the tort action was going to be tried first, it did nothing. It came in on the eve of trial with an emergency motion, which it couldn't even file under Rule 9A because it was too late, to not try that case first, but to participate. And if you read Judge Davis's decision, he said that's unworkable, because what they wanted to do is the lawyers that they paid to go in and defend Mr. Padovano would come in and say it was an accident and he wasn't negligent, and then Commerce here would come in and say, that's not true, it's an intentional act, he intended to kill him, and he pled guilty to manslaughter.
Seems like it made perfect sense at the time, but then when you get this settlement where everyone's on the opposite side, does that change things at that point? Because then it's really like a one-sided fight at that stage, and there's no one there to defend their interests. And then it becomes odd.
I
to
think
have
there's
this-
absolutely people there to defend their interests. They've paid the two attorneys they paid to represent their insured. The interests of the insured at the trial on the damages are exactly the same interests as Commerce. They want the judgment
No, they
to be
don't.
as little as possible so they don't have to pay.
That's silly, isn't it? Because at that point, the insured is off the hook and feels terrible probably about this death, and can jack up the amount with no consequence to him, right?
No, Your Honor. What happens usually in these cases is you agree upon an amount. Here, rather than just pick a number out of the sky, we decided to have it litigated before a Superior Court judge. So if you call this a sham, you have to call it a sham with some judicial
I'm
approval.
not saying, it's not a sham, but it's not a real trial. It's a one-sided trial to set damages with no, and we don't have comparative negligence. We don't have, that it was really a murder or manslaughter. We don't have any of that in the mix here.
I can address that in two ways, Your Honor. First of all, any seasoned trial attorney would admit liability in that trial, because if they don't, they have to bring, if they admit liability, you don't bring in the murder, you don't bring in the drinking that night, you don't bring all the
Well, I think
conduct.
it's brilliant on the part of the insured, but the insurer's interests aren't being protected in any way here.
They are, because under Campione and under Spellman and under all of the cases, they have the right, and this is what Judge Davis wrote, citing the Atwood case in Maryland, they have the right afterwards to try these issues again if they think they were not
Yeah, no,
properly litigated.
that may solve all the problems, but I don't think it's a fair damages hearing at that point. There's no
Try all
one,
these issues, meaning try negligence, or
They-
just damages.
If you, Judge Davis's opinion, it's page 79 of the first appendix, it's page 9 of his decision, spells out in the Atwood that any issue that you believe is under litigated, you can then raise again on the deck action, which is exactly why you have to try the tort case first, because if you don't, you can't say it was under litigated and fight it in the other action afterwards. In fact, on page 9 of his decision, citing Atwood, he says this is why tort actions have to be tried first, so that if they're under litigated, those issues can be brought up at the deck action following it. And that's,
Oh, sorry, go ahead.
go ahead, Your Honor.
So they have prevailed, at least at trial, on the deck action.
Correct.
Is it your contention that they still owe you the post-judgment interest?
If they do not owe the post-judgment interest because of the $500,000, what they owe us now is the fact that they've never paid the post-judgment interest on the 20. Had they come in the day after the decision and said, here's your 20, here's 1 day's interest, I don't think we'd have an argument. The only argument we have now on post-judgment interest is because they're trying to take advantage of a clerical error and not pay that extra portion of post-judgment
But are
interest.
you saying they only owe the post-judgment interest on the 20,000, or are you saying they don't they still owe post-judgment interest on the 8 or 9 million.
Whether it's 20,000 or whether it's 500,000, the contractual portion of the policy says you owe post-judgment
I
interest on
understand,
the
but
entire.
but what do you contend that they owe? The post-judgment interest on the 20K or the post-judgment interest on the 8 or 9 million?
On the judgment,
On the 8 or 9 million?
yes.
Okay,
Because that's what the contract
How are
says.
they, are you saying that they can now litigate to say, no, we shouldn't, that $8 or $9 million judgment was inappropriately done, and we can now litigate what is the amount of post-judgment interest?
They could relitigate the damages in the deck action if they chose. That's what Campione says, that's what Spellman says, that's what Miller-Shugat says, and that's what Judge Davis says. Judge Davis said, any important issue you want to relitigate, in fact, in page 9 of Judge Davis's brief, he even talks about a potential damage verdict. He says, the insured with no legal avenue to challenge a potentially collusive damage award would be against public policy. So what he's saying right there is if this was a collusive aberration if we had picked a ridiculous number, they would have every right to retry that in the deck action.
And you say they've waived that by not bringing it up?
They didn't bring it up at the action. They didn't bring it up at all.
You're saying they've waived it?
I would say that. They had the right to do it. They tried the case. They had the right to fight, like you had talked about earlier. They relitigated liability. They won. We came in second. They proved that it was an intentional act, which brings up, getting back to what I wanted to talk about, why the tort action should go first. If this went first, they've taken away the duty to defend their own insured, because now Mr. Padovano can't argue at the tort trial that it was negligence because he's estopped under res judicata from the decision saying he intentionally killed the person. If we did it the other way, we'd be back to a damages trial the very way that it happened, because there is no defense. There is no contributory negligence because it's an intentional act. There's no defense to the punitive damages because it's already been cited to be intentional. He can't get out of it in bankruptcy because it's an intentional act. If we had done that action first, they would have crippled their own insured's ability to defend in that action. And all this talk about comparative negligence defenses, there isn't one because they've proven that it was an intentional act. The second, if I can get back to the untimeliness.
I'm trying, I mean, you're faster than I am, so let me just make
Sorry,
sure I
Brad.
understand. So you're saying that we don't want the duty to defend action to be done first, because if their duty to, I'm sorry, the reservation of the DJ action to be done first, because if they prevail, they would also prevail on having no duty to defend?
Here, they would have obliterated their duty to defend because Mr. Padovano can't try his case and say it's a negligence because there's already a finding against him that he intentionally killed the person. And he was a part of that trial.
There's collateral estoppel as to the issue. You're not saying that they would say, we no longer have a duty to defend, therefore pay for your own attorney, because now we need not pay for the attorney.
Agreed. It doesn't take away the duty to defend, but what's left when you've already determined that he's intentionally killed the person? There's nothing left for him to really defend against. He's admitted liability for the damages trial and the tort action.
Okay?
The second, now, we had that May 9th date, which they had 6 months where they did nothing. We then kicked it 6 months to December, so the insured picked up another $500,000 in prejudgment interest. And the insurer, again, at the last moment, 14 months after this date was originally set for trial in November of 2016, for the very first time, filed the motion to try the deck action first. That was denied. Part of it, obviously, because of the timeliness. We've already had the families of these two, of the decedents here, twice have to get prepared for trial and take the scars off the wounds and go forward and prepare for them. And at the very last moment, for a second time, the insurer decides, let's kick it down the road some more, which comes into your argument, Judge Kafka, about the interest is still going because it's such a large amount. And so for that reason alone, the judge had reason not to allow their motions. The third one was done on the day of trial. As far as the last thing, they couldn't have tried the deck action yet because we hadn't finished discovery. You'll see they filed the motion to amend the complaint on the day of the trial. In addition to which, you'll see in the docket that in July of 2017, they were still fighting what categories their 30B6 deponent would be allowed to testify on.
Don't we want to discourage the separation of the deck action from the negligence? A lot of problems seem to come from the fact that these things are separating and there's going to be a big time difference. All the incentives start getting screwed up here.
Well, in this particular case, 3 months after the deck action, they were joined for discovery. All the discovery came together. When this was set down for trial, if Commerce really thought there was a prejudice to them, they should have asked at that time.
I'm more concerned about prospectively the guidance we're going to give out there, because, you know, these rules, that you don't like all these settlement rules they're proposing, and they seem very cumbersome, but it seems like it becomes a real problem to allow the deck action and the tort action to separate here. And shouldn't we be telling the judges not to allow this type of separation here, that they got to move right to the next issue, or we're going to have a massive train wreck like we have in this case?
I don't think that you can do that for two reasons.
Okay.
One is, here where they were joined, most of the discovery was completed, but the discovery against Commerce was not completed. We still had the 30B6 deposition.
But that's something the judge can force. He can prevent one case from being ready before the other. He can make you do both, because, right? I mean, again, there may be practical problems. The four of you do this for a living. I don't. But it just seems like everything flows from the fact that these two cases separated. And dramatically, it took 2 years for a decision on the deck action.
I think it would be unfair to the insured and the plaintiff, because the insured incurs all of the prejudgment interest, and there'd be no reason to hold up his trial because the discovery wasn't completed in the deck action. And conversely, if it was a clear deck action that they could get summary judgment well before the tort, they could do it the other way. Secondly, this was an aberration, and that first, Commerce never moved to get a trial date. Second, they moved to amend the complaint on the day of the tort trial. Third, they fought the 30B6 depositions right through 2017. Four, they didn't allow us to depose their expert until after the pretrial, 1 week before the July 2018 trial. And five, the first judge who was going to hear this had a medical emergency, so it had to get rescheduled. It got rescheduled to Judge Campo, who had a conflict because he previously represented Morrison Mahoney, and that's why it got to this date. Normally, in the normal course of things, this would not happen, but because Commerce delayed the discovery and because of two things with the judiciary that no one could have prevented, that's the only reason why this case was so far afield from the first one.
Can you address one thing which nags at me, which is that this resolution settlement is one that nobody who actually would have had to pay the money would ever have entered into, because it is, for all practical purposes, a default. I mean, its practical consequences no different than the defendant saying, we now default, and they move to a damage assessment hearing and get the entire amount of damages which would be due if you had prevailed at trial. I mean, that's not any settlement of matters that would be hotly litigated if people who actually were going to pay the money were involved. Why is it fair to essentially allow the equivalent of a default judgment to carry on here, where the people who are essentially defaulting have no skin in the game?
That's been the precedent of this court for over 72 years, going back to 1947 with the Salinon decision, where the judge said that when an insured under reservation of rights, an insured has every right to protect himself, and that's why these are done. That was followed up almost 50 years ago in 1970 in the Three Sons case. It was followed up 30-plus years, 33 years ago in Campione. There is a 3/4 of a decade precedent that whenever an insurer abandons its insured, they have the right to enter into these agreements, because otherwise they're put in an unbelievable predicament where they may have a very, very large verdict against them for which the coverage they paid for is not available.
Okay, thank you.
Thank you.